Tenants will want to know what's likely to cost them the most in the future. Obviously they know what the rent's going to be until the rent review, but there's unknown liabilities as well, such as service charge and dilapidations. So if a repair covenant's drafted so that the tenant has to hand it back in a better condition than they took the lease on, then that's a potential cost that they need to be aware of. Clients often want to know what the Landlord and Tenant Act 1954 implications are. This is an act which gives the tenant much more protection when it comes to the end of the lease, because they're entitled automatically to a new lease. The landlord will often want to exclude that, and it's important that the tenant is aware of the implications of that act. I always advise both landlord and tenants to get some legal advice when the heads of terms are being drafted. This is the document which provides the bones of the transaction. It's not binding, but it's a good framework, and it means it could save costs further down the line because you've got the agreed terms set out, and then it's for the lawyers on both sides to put flesh on those bones. If the heads of terms are properly drafted and agreed at the outset, then this could save a lot of time and money in the future. Yeah, there's various elements of a transaction that the clients may not be aware of, and it comes up during the course of the transaction, which is why we always do a report before contracts are exchanged, so it puts the legal terminology into hopefully plain English for them.